All right, they say it penalizes poor defendants and lets the wealthy go free.
More and more district judges are declining to impose cash bail and releasing certain defendants with nothing more than a signature. But is that putting the public at risk?
KDKA lead investigator Andy Sheehan reviewed hundreds of cases to try to find the answer.
Giancarlo Cepeda, arrested at the Greyhound station, charged with possession with intent to sell 9 kilos of fentanyl. Released on no cash bail, he failed to show at his hearing and was later captured in New York City. Hermes Craddock, arrested after leading police on a high-speed chase, released on no cash bail. He failed to show and was later apprehended on a fugitive warrant in Florida. Antonia Casium, also released on non-monetary bond on charges of assault and fleeing arrest. They failed to show at their hearing and were later arrested under their legal name of Anthony Casium in the random and tragic stabbing death of Benjamin Braillier on the Montour Trail. In all 3 cases, District Judge Xander Orenstein followed a policy of not imposing cash bail, a policy that frustrates police and advocates for victims say puts the public at risk.
It's not fair to victims. It's dangerous. That's when people die. That's when people get hurt.
In light of these bail decisions, Orenstein has been removed from hearing arraignments, but a half-dozen other district judges in Allegheny County adhere to the same philosophy of not imposing cash bail, which they say unfairly penalizes poor defendants.
It does create a 2-tiered justice system where people who are unable to pay get stuck in jail and people with means are able to post and get out of jail.
District Judge Matt Rudsky says bail has but 2 purposes: ensuring the defendant will show up for their preliminary hearing and guaranteeing the public's safety. In most cases, he says, the defendants do not pose a danger to the public and bail is not required. But there are cases where they are a threat.
If I determine that someone, no condition or combination of conditions can guarantee the safety of the public, then I will deny that individual's bond.
Cash bail is a distraction. It's not the issue. The issue is who should stay in jail and who should be allowed to leave.
KDKA Investigates reviewed hundreds of arraignment decisions of district judges who ran on platforms of not imposing cash bail. And true to form, they rarely did. But in some cases, they did deny bail entirely, guaranteeing the defendant would stay in jail at least until their preliminary hearing. Duquesne law professor Bruce Ledowitz, who opposes the imposition of cash bail, says this is essential for the system to work.
The system of no cash bail will work fine as long as magistrates are willing to deny bail to people who should not have it.
But that system isn't foolproof. Of 138 arraignments, District Judge Lisa Caulfield never imposed cash bail, denying bail 22 times. But not in the case of Dantes Peoples, whom she released on no bond despite him fleeing police, who allegedly found 40 bricks of heroin fentanyl in his Northside apartment. And Rudsky appears to regret not denying bond to Roderick Hatton after Bethel Park police arrested the Arkansas native for carjacking. After releasing Hatton on no monetary bond, he was rearrested for trying to break into the Bethel Park police station to retrieve his belongings. Rudsky calls that decision an outlier, saying he is more inclined to deny bond than most judges.
No system is built perfectly, so we try to do the best we can with the knowledge that we have. And we don't have crystal balls.
Can cash bail be eliminated and still keep the public safe? Despite the actions of Orenstein, several district judges are trying to do just that. But it remains a work in progress. And in that sense, the jury is still out. Reporting in the newsroom, Andy Sheehan, KDKA-TV News.